Excellency, members of the Centre, thank you very much for the opportunity to come and talk to you today, and congratulations to the Centre on this and the other initiatives it's taking to make competition policy a reality as is happening around the world. Now, my role today is to provide a context. As the slide says, many countries are on the road to economic and social welfare through competition policy, and my role is to set the context for that by referring to what is happening in other parts of the world. Now, this looks like, with apologies, Excellency, looks like an economic lecture. It isn't. I'm not an economist. I'm a practicing lawyer, as the introduction indicated. And so my interest is actually in the journey that others have taken in developing competition policy and turning competition policy into competition law. And I hope that the journey that we go on this morning will help you to place in context not only the excellent work that the Centre is doing on an ongoing basis, but the presentations that will follow. Now, although this is about competition policy, I'm Australian and Australians love sport, so I want to start by talking about sport. Football and cricket are really popular games in Australia, and so when I learned I was coming to Oman for today, I wanted to see what sports were popular in Oman. So I went to that marvellous site, the Oman Observer online, and I found that football and cricket are also popular sports in Oman, so we have much in common. Not only that, I found that in cricket, your team was doing extremely well internationally. It's just beaten Hong Kong, and according to the Observer, it thrashed Ireland. In football, you're doing even better. It beat India last month. Your football team, the Red Warriors, I think, beat Afghanistan last week, and there's a major game coming on with Qatar in the next couple of days, which promises to be an exciting event. So I hope I'm here to see it. Now, unfortunately, the news from Australia in football's not quite that good. My team, the Canberra Raiders, played for the first time in 25 years in the final of the Rugby League last week. It was an exciting game. Throughout the game, for most of the game, it was drawn 8-8 draw until the last 5 minutes, when the other team found a breakthrough, went through the pack and ended up winning the game. So I'm not as upbeat about football as perhaps I would be if I watched the game between Oman and Qatar. But it thinking about sport started me to think about what it is about sport that we value so highly. And the answer, of course, is quite simple and straightforward. We value the spectacle of elite athletes battling it out to succeed, whether they win or lose. We value the fact that there are fair rules consistently applied by neutral umpires. And we value that everyone has a fair chance of succeeding on the merits. In other words, we value the competition. Now, what does sport teach us about the basic requirements for effective competition? Sport has three important attributes. First, rules that give every participant a fair opportunity to win. Second, a neutral independent umpire to uphold the rules. And third, fans, or in other words, stakeholders and community support. Without those three elements, no sport would be successful. We just wouldn't be interested in watching. Now, let's think about that in the context of an economy as a whole. The same considerations apply. Every manufacturer, service provider, importer, and trader should have an opportunity to succeed on the merits. But that's not possible without fair rules with which all, or at least a majority, comply. Rules that are consistently upheld by a neutral, independent umpire. Now, European adherence to what in economics literature is referred to as the ordoliberal view put it this way. They say, and I quote, "What is required is a system that is able not only to avoid unwarranted government intervention in economic affairs, but also to effectively control the market power of private actors." Now, while, as we will see shortly, views on the roles of competition policy vary and have developed with different schools of economic thinking over the past 80 years, that is what competition is all about. It is in essence a rules-based system that enhances social and economic welfare by controlling market power while avoiding unwarranted government intervention in the market. That balance has proven to be harder to achieve in practice than it might appear, as we will come to shortly. Best practice tells us that if competition rules are to deliver improved economic and social welfare while avoiding unwarranted government intervention in the market, they must address the same four elements as are necessary for a successful sport. There must be clearly understood competition rules, an effective, neutral, independent regulator upholding those rules, and stakeholder and community support. First and foremost, competition rules need clear policy objectives. And this is where the sports analogy breaks down a little. With sport, the objective is clear: to win the game being played and to do so fairly. But when it comes to competition rules that apply across an economy, policy objectives become far more complex. Let me first deal with that by recounting the journey others have been on. Progress towards improved economic and social welfare utilising competition rules has been a long and somewhat arduous journey. Let me take two examples. The first is the United States. Statutory competition law has its origins in the 1890 Sherman Act. That act was motivated by public concern about abuses of power by large and powerful conglomerates, especially in the oil, railway and tobacco industries. There was widespread public hostility to the corporate behaviour of John D. Rockefeller and other industrialists, especially in the depressed agricultural communities, trying to deal with ever higher costs of rail services. Academic economic views did not feature. Although today, the Sherman Act is regarded as a pathfinder piece of economic legislation, quite justifiably. My second example comes from Australia. Growing domination of industries by foreign enterprises prompted the first and unsuccessful attempt at anti-monopoly law in 1906. A common complaint in and out of Parliament at the beginning of the 20th century was that infant Australian industries were falling into the hands of foreign corporations, particularly those of United States origin. Indeed, that had happened in petroleum, tobacco and the beef industries. In introducing the first Australian anti-monopoly legislation, the Minister stated, and I quote, "I feel that no excuse is necessary for the introduction of the bill, but if it were, it could be found in the statements published in the newspapers of the United States of America, showing the dimensions to which the enormous octopus trusts of that country have grown and the harm they have done by buying up, destroying the smaller internal business concerns of the United States." It was public reaction to unacceptable conduct that may have been the original driver for competition and anti-monopoly laws, but as the 20th century progressed, focus on competition policy as an economic drive came onto competition policy and increased as an economic driver for prosperity. That prompted legislators to ask, first of all, me to ask which way I click. That prompted legislators to ask questions such as, is it in the public interest for manufacturers to only supply those retailers who agree not to handle competing brands? Or who agree only to resell at the manufacturer's specified price? Is it in the public interest for trade associations to tie up suppliers so that only members can obtain products and not non-members? Is it in the public interest for dealers to have exclusive territories? Is it in the public interest for powerful retailers to extract discounts from manufacturers that are not available to smaller retailers? Now, legislators also ask themselves whether, if restrictive practices such as those I've just listed are not in the public interest, which ones are so presumptively contrary to the public interest that they should be banned absolutely? And that remains an open question today. Now, as empirical work in the field of economics developed through the second half of the last century, we came to realise that competition policy could deliver tangible economic and social benefits. There is now an overwhelming body of economic literature on the nature, cause, and effect of competition. Admittedly, there are different views among economists about what the objectives of competition policy should be, and I'll come to that in a minute. Different schools of thought, the Freiburg School, the Harvard School, the Chicago School, the Austrian School, to name four, have emerged with different and often competing views. In the language of economists, should the goal be economic efficiency? Should it be improved consumer welfare? Or should it be improved total welfare? Now, as I've already admitted, I'm not an economist, I'm not going to get into those issues. I will only observe that each country is different and must choose the objectives that best suit its own needs and aspirations. Whatever those aspirations may be, economists around the world would agree that effective competition policy delivers the following benefits identified by the OECD. First, lower prices for all. As the OECD has explained, the simplest way for a firm to improve its market share is to offer a better price. In a competitive market, prices are pushed down. Not only is this good for consumers, making products more affordable, but it encourages businesses to produce and boost the economy in general. Second, better quality. Competition encourages business to improve the quality of products they sell, to attract more customers and expand their market share. Now, quality can mean a variety of things here, that products last longer or work better, or there's a better after-sales or technical support, to use some examples drawn from the OECD work. The third OECD identified benefit is more choice. As the OECD points out, in a complex market, businesses will try to make their products different from the rest. This results in greater choice, so consumers can select the product that offers the right balance between price, quality, and features. Next, the OECD identified innovation. Businesses in a competitive market need to be innovative in their product concepts, design, production techniques, services, etc. Without innovation, improved quality and increased choice is not possible. And finally, better competitors in global markets. The OECD points out that strong competitors in home markets are better able to compete internationally. Now, there's also, beyond what the OECD has indicated, a view that some say effective competition laws improve opportunities for foreign investment. And as you may well be aware, the new Saudi Arabian law, the announcement of that law was very much focused on the need for greater transparency in the competition policy area and to improve transparency for improved foreign investment. Now, as the benefits listed by the OECD to which I've just referred illustrate, competition is not an end in itself. Competition is valued for the benefits it provides for citizens and for national economies as a whole. So it's not surprising that different countries have drawn on competition policy for a range of worthwhile objectives. And what I propose to do is take you through a tour of a number of those objectives to give you a sense of the breadth. Now, as a survey by the OECD in 2003 found, respondents thought that the basic objective of competition policy should be to promote efficient use of resources while protecting the freedom of economic action by market participants. But the study also found that in many countries, competition policy has been directed at achieving or preserving a range of supplementary objectives. These include, and I quote, preventing abuses of economic power, promoting small business, fairness and equity, and other socio-political values. Now, a survey on the objectives of anti-monopoly laws, Article 10 in the Oman law, is the example, was conducted in 2006 by the International Competition Network. Competition agencies identified 10 different objectives. All but one identified multiple objectives. The ICN reported that, and I quote, virtually all responding agencies cited ensuring an effective competitive process as an objective in its own right. But they saw this as a means to achieve other desirable goals, such as consumer welfare, economic freedom, or efficiency. From that survey, the broader range of objectives included ensuring economic freedom, ensuring a level playing field for small and medium-sized businesses, promoting fairness and equity, promoting or enhancing consumer choice and consumer welfare, achieving market integration, which I note was originally a primary driver for the EU competition laws, promoting competitiveness in international markets, and increasing productivity and the opportunity for foreign investment in small economies. Now, I'm going to use 4 practical examples to illustrate how the range of objectives that I've just referred to have been adopted in some other countries. The first is Jamaica. The aims of the Jamaican Fair Trading Commission are to, and I'm quote, ensure that all legitimate business enterprises have an equal opportunity to participate in the Jamaican economy. The second is South Africa's competition law, which goes further than the Jamaican law. That law states, and I'm quoting from the law, that the objective is to promote and maintain competition in South Africa in order to achieve 6 diverse objectives. And they are promoting the efficiency, adaptability and development of the economy, providing consumers with competitive prices and product choices, promoting employment and advance the social and economic welfare of South Africans, expand opportunities for South African participation in world markets and recognise the role of foreign competition in the Republic, ensure that small and medium-sized enterprises have an equal opportunity, an equitable opportunity, to participate in the economy, and finally, to promote a greater spread of ownership, in particular increasing the ownership stake of historically disadvantaged persons. My third example comes from the Philippines. Their law contains an explicit declaration of policy. That declaration provides the state recognises that past measures undertaken to liberalise key sectors in the economy need to be reinforced by measures, need to be reinforced by measures that safeguard competitive conditions. The state also recognises that the provision of equal opportunities to all promotes entrepreneurial spirit, encourages private investment, facilitates technology development, and transfers and enhances resource productivity. Unencumbered market competition also serves the interests of consumers by allowing them to exercise their right of choice over goods and services offered in the market. Finally, I'll refer to the new competition law of Saudi Arabia, which I understand came into effect just a few weeks ago, although Saudi Arabia, of course, has had a very active commission for quite a number of years. This is the most recent example. Their law states, the law aims to protect and encourage fair competition and to combat and prevent monopolistic practices that affect lawful competition or consumer interest, leading to an improved market environment and economic development. Now, many of these considerations are not dissimilar, and of course, they're apparent in Article 2 of the Oman Law and in Article 4 of the statute establishing the Centre. And as these practical examples illustrate, others on the journey to improve social and economic welfare have concluded that in their particular circumstances, competition policy can serve a wide range of social and economic objectives. Now, economic and social considerations set the direction for competition policy, but law is the instrument that specifies the rules to achieve those chosen objectives. It follows that to be effective, competition rules need to be clear and clearly understood. Without clearly understood rules, there can be no progress towards improved social and economic welfare through competition policy. And that takes me to the first of my 4 original best practice requirements. Economic concepts inherent in competition law, to quote a few, market, competition, monopoly, economic concentration, to name a few, are not generally well understood terms. Indeed, in Australia, it took quite some time for lawyers and judges to come to grips with what they meant. I'll return to this point a little later. Each country's competition law is, of course, expressed and administered differently. This reflects each country's history and social and economic circumstances. But in essence, there are four basic rules of virtually universal application in the over 120 countries throughout the world that have modern competition laws. What are those rules? First, businesses should compete, not collude. Secondly, big business should not muscle out small businesses. Third, businesses should be free to set their own prices, not required to charge the prices set by the supplier. And fourth, businesses should not corner markets by buying up competitors. Of course, when translated into legislation, these rules become more complex, but they are the basic rules on which competition laws around the world are based, from the small Pacific island country of Fiji to the large countries that make up the European community. The Oman law reflects each of these basic rules. It's not necessary for me to do more than illustrate the way it does so, taking a few examples. Article 9, practices for the purpose of preventing competition may not be concluded. Article 10, any person having a dominant position may not practice any activity that may infringe, negatively affect, eliminate or prevent competition. Article 9, practices for the purpose of preventing competition regarding pricing, discounts, sales or purchase terms and conditions may not be concluded, and that's supported by other provisions in Article 8. And Article 11, persons intending to take any action resulting in economic concentration shall submit a written request to the authority, in effect for approval of the merger. Now, I referred earlier to there being over 120 countries around the world with competition and anti-monopoly laws. I've mentioned a few already, but I should pause here to observe that many have introduced competition laws quite recently, and so I should take some examples. New competition laws were introduced in 2010 in Pakistan and Mongolia. In 2011 in Malaysia, in 2013 in Algeria, in 2015 in Hong Kong and the Philippines, and in 2017 in Thailand. Turning to countries more proximate to Oman, new competition and anti-monopoly laws were introduced in 2004 in Jordan, in 2005 in Egypt, in 2006 in Qatar, in 2012 in Kuwait and the UAE, and in March this year in Saudi Arabia, although that law and some of the other laws replaced existing laws and upgraded them. So in introducing the Oman law in 2014 and establishing the centre to administer it, Oman is in excellent company. What are the problems that have been addressed in a practical sense in other countries? If stated in broad terms, the objective of competition rules is to improve economic and social welfare, what has been the practical position in other countries? What types of conduct in practice have the rules been applied to? Now, it will take a very long time for me to give you a comprehensive answer to that question. Indeed, in the Australian context, my book, which is over 2,000 pages, is peppered with examples of cases over the last 20 years. Internationally, there are two key areas of primary focus for competition authorities. They are cartels and monopolies. To illustrate in relation to cartels, I'll draw on two case studies. In the first case, the facts are these. A company executive said goodbye to his wife and children one morning and went out the front door on his way to work, as he did every day. But instead of getting into his car, he strolled down the street to a nearby telephone box. He was on a mission, coins in hand. He was going to make a call. Who was this executive? His name was Lonergan. He was the divisional chief executive in George Weston, one of the two major Australian flour milling companies. He telephoned the mobile phone of an executive he knew at Manildra, the other major flour milling company. As it happened, that executive, Simpson, was driving his car at the time. He took the call on his hands-free speakerphone. Lonergan told Simpson that his company, George Weston, intended to increase the price of flour. He asked what Simpson's company was going to do about it. Simpson's response was that he'd have to talk to his boss. Now, as luck would have it, Simpson's boss was in the car at the time and overheard the conversation. Things unravelled from there. The call was reported to the Australian Competition and Consumer Commission, and a significant penalty resulted. My second example of cartels involves an investigative reporter in the Netherlands. In November 2001, a nationwide television program, aptly titled Fiddling with Millions, was aired on Dutch television. It reported on the results of an investigation into the Dutch construction industry. The program sparked a political controversy in the Netherlands. The program centred on allegations by two whistleblowers of widespread bid rigging in relation to public procurement in the construction industry. The whistleblowers produced financial statements showing a systematic bid rigging on about 3,500 construction projects for the government in the Netherlands, a very small country. I've drawn on an article by Dutch academic Professor Doré, who explained how the cartel worked. He said, for hundreds of these projects, it was noted how much compensation the winning contractor had to pay the unsuccessful competitors. All bids had been adjusted, that is rigged, so that the outcome of the tendering process was inevitable. Now, what was inevitable was the result. It was a parliamentary inquiry, as well as investigations and prosecutions by Dutch competition authorities. Professor Doré reported that in March 2002, over 500 police officers, fiscal investigators and prosecutors invaded companies, agencies and the homes of those suspected of being involved in over 50 locations. It was the largest invasion in Dutch legal history. The bid rigging was said to have cost the Dutch taxpayers about €500 million each year, €500 million each year. Now, at this point, it's appropriate for us to pause because whatever I say here can never be as graphic as seeing it actually in action. So what we're going to do is show part of a video, also shot by the then Dutch competition agency, which shows graphically how cartels unravel. It's shot like a surveillance video, so it's not crystal clear. It creates a real-life atmosphere, and so I'll let you make up your own minds.
Nou heb ik hier 3 aanvragen van klanten van jullie. Zeg maar wat de quotes zijn en hoeveel ik erboven moet gaan zitten.
Ja, voor deze hier wil ik preferentie. Ik ga voor 4,50. Gaan jullie er 8% boven zitten?
Die klantenverdeling die klopt wel. Ik maak me alleen nog steeds zorgen over het prijsniveau. We moeten uitkijken dat bij deze opdracht niet te veel opvalt.
Door prijsverlaging of door juist dichter bij elkaar te gaan
Dat
zitten?
doet er niet toe. Helemaal, die zit echt niet te slapen hoor. En dit is een opdracht die veel aandacht krijgt, let maar op. Vergeet niet dat die klant uit Eindhoven vorig jaar dreigde naar de NMA te stappen, hè?
Ja, dat deed hij niet omdat hij geen poot had om op te gaan.
We kunnen in de toekomst best een aantal zaken lager prijzen vanwege die groeiende concurrentie uit het buitenland. Maar zoals jullie weten willen Lex en ik juist een hogere marge. Daar moeten we het zeker nog een keer over hebben.
Anders zit hij natuurlijk helemaal voor niks. Doe er even nou voor zin als wij onze marges niet gewoon flink hoger leggen dan de gewone concurrentie. Leo, wat moet jij over die klant van jou?
Daar gaan we een flink eentje boven 1,2 zitten. Komt er zeker van.
Toen hoor.
En dan hebben we ze rond. Nog een keer op de Wagenmakerstraat.
De Nederlandse mededingingsautoriteit deelt forse boetes uit aan 6 ondernemingen in binnen- en buitenland. De kartelwaakhond spreekt van een eenschappelijke overtreding van de
Wat? Ja. Oh ja.
De structuur die jij hier noemt komt neer op een kartel. Het boetemaximum daarvoor is 10% van de wereldwijde omzet voor alle betrokken ondernemingen. Daarnaast kan de NMA ook nog persoonlijke boetes tot €450.000 opleggen aan de mensen.
Privé verantwoordelijk?
En ook wanneer zij, ook wanneer zij op afstand hebben geopereerd.
Wat ik wil weten is hoe ze erachter komen. Doet de NMA invallen bij bedrijven? Werken ze met tips? Hoe werkt de NMA eigenlijk?
Nou, de NMA kan bijvoorbeeld reageren op een klacht van een klant die geconfronteerd wordt met te hoge prijzen. Of een van de karteldeelnemers stopt bij de NMA in de hoop op boetekwijtschelding op grond van de clementieregeling.
Het clementiebezoek. Kun je daar iets meer over vertellen?
Now, the video goes on for another 6 minutes, but I think you can work out how it finishes. It doesn't finish well for any of those people who met in that hotel in the countryside somewhere in the Netherlands, other than, of course, for the person who was the whistleblower. Let me now turn to monopolisation, the second major preoccupation of competition agencies worldwide. The first point to make is that monopolisation cases, referred to in the EU as abuse of dominance and in Australia as misuse of market power, are notoriously difficult. This is not only because they pit competition agencies against some of the largest firms nationally and often globally. It is because there is no clear bright line between conduct that is benign, tough competition on the merits, and conduct that crosses the line. It's not the size of a firm as such that concerns competition agencies. Large firms can deliver significant consumer benefits through innovation and efficiencies that result in lower prices. It's only when they use their market power to take unfair advantage that competition agencies become involved. Now, I'll illustrate with 2 examples, but on this occasion I'm going to tell you what the outcome was. The first is drawn from the pharmaceutical industry. Assume that a pharmaceutical company has one product for which it holds a current patent and is therefore the only available supplier. And the other products it has, there are available substitutes. Now, in responding to a tender to supply pharmaceuticals required by public hospitals, the company offers each of its products separately, but it also offers to supply all of the products required by the hospital in a bundle at a very attractive lower price. If the hospitals take the bundle, there will be a significant price saving, but competing suppliers of some of the pharmaceuticals will be excluded. Is that competition on the merits or exclusionary monopolistic practice? The second I'll draw from is in the construction industry and brick manufacturing. Assume that the only manufacturer of building bricks in a metropolitan area faces competition from a new entrant brick factory. The new entrant factory has more modern, more efficient production equipment. Now, faced with a downturn in the construction industry and the oversupply of bricks as a result of the new competitor coming into the market, the original manufacturer, drops its prices. In fact, it drops them so low that the price is below the new entrant's prices and arguably below the manufacturer's cost to make and sell its products. Is that competition on the merits or exclusionary monopolistic conduct? Now, the 4 examples that I've used so far are drawn from actual cases, but those are cases decided over 10 years ago. What's the state of play internationally today? What's actually happening in the marketplace today? To give you a flavour of what's happening in other countries, I'll draw on 7 current examples reported in the past 3 months. So these are cases that have been actually decided by competition agencies around the world in the last 3 months. First is in Malaysia. The Competition Commission proposed to fine a Singapore-based ride-hailing company, Grab, for preventing drivers promoting services of firms that competed with Grab. Now, Grab was the result of a merger with Uber, and it became the dominant ride-hailing company in Malaysia. The Malaysian Commission has provisionally found that Grab abused its dominant position. The Commission said the restrictive clauses had the effect of distorting competition in the relevant market, by creating barriers to entry and expansion for Grab's existing and future competitors. The second example I use comes from Mexico. The Anti-Monopoly Agency fined Cancun International Airport an equivalent of $3.75 million US for not allowing more taxis to compete and thereby lower fares for passengers. Now, the reason that they did this was that the airport company, was getting a payment, a percentage of every taxi fare. And so the Cancun Airport's revenue was affected by this arrangement. And the Anti-Monopoly Agency calculated that in keeping fares high to maintain that income, the airport had in effect imposed prices on the community that were 8% higher than they might otherwise have been. The next example is a really interesting one. It's a small country, and I understand Richard Wish has just been there, Mauritius. In Mauritius, the Competition Commission has ordered Visa and MasterCard to cap their interchange fees after the agency found that credit card issuers abused their dominance by setting unreasonably high rates. This is an example of a situation. It's often thought by small competition agencies that it's not possible to take on the big players, global big players, but this is a very real example of a small agency taking on a big player. The Commission found, I'm quoting from the report in African Antitrust, the Commission found that Visa and MasterCard had set an interchange fee of 1%, which in turn led to a higher merchant fees. Now, in an Australian context, I've got to tell you 1% is a very low fee, but obviously in Mauritius it wasn't the market fee. As a consequence, the interchange fees were found to have hampered the incentive for banks to issue credit or debit cards and to provide card facilities to merchants. This had led to either some merchants electing not to have cards, not to accept cards, or to increase the final price to consumers. My next example comes from South Korea. The Antitrust Agency fined the 4 largest automobile parts makers from Japan a combined total of $76 million US for fixing the prices of auto parts. According to the Korean Herald, the Korean Herald reported that according to the Fair Trade Commission, 4 Japanese car firms had fixed prices in collusion when setting alternator and ignition coils to local automakers, and they'd done so for about 10 years. So you can imagine how long the people in our video might have been meeting in faraway places in little hotels around the Netherlands and concocting false bids. My next example, and these examples are drawn at random from across agencies around the world. They're by no means a comprehensive review of the situation. In Brazil, the Antitrust Agency announced a probe into a possible existing cartel. Now, the cartel was said to affect the cost of construction and remodelling of the country's soccer stadiums for the 2014 FIFA World Cup. According to reports in America Economer, the investigation began with a leniency agreement, was reached, same as in our video, with the Brazilian authorities by the large construction company Andes Guerreiras, one of the largest in the country, and several of its former executives who were also covered by the immunity agreement. If I return to South Korea, the South Korean agency has fined a local tyre manufacturer for forcing its dealers to sell tyres at higher prices, and the list goes on. To finish off, in Turkey last month, the Competition Authority commenced investigating a complaint that 4 cement companies had engaged in a cartel to fix cement prices and allocate customers, another example of our video. The hearing on that complaint is being held tomorrow. Now, as I've said, these are not isolated examples. These are examples of conduct that is at risk in any country that has a modern competition law, including, I imagine, in Oman. Let me now turn to the second best practice requirement, a neutral umpire overseeing an effective system upholding competition rules. International experience shows that while it may be satisfying to have competition law on the statute books, an effective system of upholding the law, overseen by a special umpire, is essential. I referred earlier to the dates on which a number of countries introduced their competition laws, but that is only part of the story. Having a competition law is of little utility without a neutral independent umpire to uphold it, as I've said. It is no different to sport. If there was no umpire at a football match, we wouldn't be much interested in attending. Now, I'm not familiar with the position in all of the countries I've mentioned, but I do know that many countries have had competition laws on their books for many years, with little or no effect. Thailand is one example, Vietnam is another. India has had an ineffective competition law from 1969 until 2003, and my own country was in the same position from 1911 until 1975. Experience globally shows us that the benefits of competition are best realised if there's a well-resourced competition agency upholding the law independently, with judgment and integrity, making the right choices of cases to pursue and the cases not to pursue, and utilising the full range of remedial options available to do so is the hallmark of a successful competition agency. I should add here that the Organisation of Competition Regulators, the International Competition Network, has provided practical assistance for many new competition agencies, assisting them to achieve their full potential, and His Excellency referred to the ICN and OECD earlier. It has done so, the ICN has done so through dialogue and its practical guidance materials. Now, returning to the video clip we've just seen, leniency policies encourage those involved in cartels to come forward and provide competition agencies with valuable information. This has proven to be a significant source of evidence needed to combat cartels. According to the OECD, over 60 competition agencies around the world have formal or informal cartel leniency policies. The ICN has reported leniency encourages cartel participants to confess their cartel conduct and implicate their co-conspirators, providing first-hand, direct, insider information or evidence. Leniency programs help to uncover conspiracies that would otherwise go undetected and can destabilise existing cartels. They also act as a deterrent to those contemplating entering into a cartel arrangement. And if we saw the rest of that video, you would have seen the process of the whistleblower making an immunity application, and then subsequently the competition agency visiting, to use a neutral term, every one of the other co-conspirators and extracting the information that was needed to prosecute them. Now, of course, Article 24 of the Oman law allows the court to show leniency, and no doubt leniency policy will be something that the Commission will consider in due course. Finally, the third best practice requirement, to which I referred earlier, is stakeholder and community support. Indeed, competition laws are unlikely to be effective without it. While stakeholder support is essential, it's proven to be problematic in many countries. This is because competition law requires a fundamental change in business attitude, particularly by those responsible for businesses essential to economic prosperity. Now, part of the problem is that competition rules are replete with the economic concepts to which I referred earlier: market, competition, monopoly, economic concentration, to name a few. These are not generally well understood terms, yet they are central to any competition law, including the Oman law. Well-established competition agencies around the world invest significant resources in effective advocacy and outreach strategies. These strategies are aimed at informing stakeholders in government, in business and the community on the fundamental competition rules and their importance. And of course, this workshop and the earlier workshop the Centre had with the Oman Chamber of Commerce and Industry are two good examples of the Centre undertaking good work in this regard. New agencies have so much to do in the early stages that often advocacy and outreach programs take second or third place. Turkey is an example of an agency that has formalised its advocacy objectives by setting them out in a published strategy plan. Recognising the challenges agencies new and old face, the International Competition Network set up an advocacy working group as one of its first endeavours. The working group provides practical opportunities for agencies to share experiences. Of course, effective advocacy can take many forms. Now, time doesn't permit me to do more than refer to a couple, but in Japan, the authority uses various tools such as public relations, public hearings, market studies, and engages actively with government and government agencies and businesses in suggesting pro-competition policies and approaches. In Finland, the advocacy strategy of the Competition and Consumer Authority is developed in an interactive way with the Ministry and with interested stakeholders. Experience shows that a consistent program of explaining the benefits of competition to business, to government, to legislators and to the community pays long-term and short-term dividends. Some agencies have made significant progress utilising a different type of advocacy. They've recognised that there are many in business that want to do the right thing to comply with competition laws. But how do large companies with many employees make sure that everyone does the right thing? One answer is rigorous and consistent compliance training. That is something that competition agencies have promoted and supported. In Japan, the competition agency undertook a survey in 2012 that showed that more than 80% of the largest companies listed on the Tokyo Stock Exchange had conducted anti-monopoly law compliance training internally. But a survey in 2016 disclosed that less than 50% of the trade associations were implementing some form of compliance efforts. Now, in closing, I'll observe that in the longer term, the academic community has a very important part to play. Teaching international comparative competition law courses in university and publishing learned articles explaining competition law and policy provides a unique opportunity to train future lawyers and business leaders in this exciting area of the law. Malaysia is an example of a competition agency that recently signed an MOU with a university to do just that, to promote and develop education and research in relation to competition law. Fostering teaching and research in competition law and policy is a tangible way to equip future generations of business leaders and lawyers with the knowledge they will need to uphold the law. So it's an exciting time for competition policy in Oman, and I'm sure your journey on the road to improved economic and social welfare through effective competition policy will be a rewarding one. Thank you very much. Excellency.
The presentation, and I think we'll take a few minutes to take a few questions. I'll speak in English because you don't have your translation ears on at the moment. You've mentioned a lot of examples of different countries, and some of them are young, just as ourselves at the center. One that caught my attention more was the advocacy tools, as we at the center believe strongly that we need to educate about the law and about the center and about competition generally. But from the examples you've given, which were the more effective tools in reaching out to your stakeholders that might very well work with Oman's current stage of developing its competition policies and tools to enact the law?
That's a very important and very interesting question, and I'm not aware, I don't know whether any of my colleagues are aware of any empirical work that indicated what the payback for advocacy was. But of course, as was shown at the start of this workshop, television clips and advertisements of the type, information sessions of the type that you showed that were shown at the start are a very powerful tool for people to get the message. Quite often the newspapers become a very important opportunity as well, simply because, for a very pragmatic way, every time the agency, whatever the agency is, takes proceedings. I'd imagine in Mauritius the newspapers would have been full of the case that was decided there. Now, agencies have to be careful about not getting too far ahead of themselves by taking on cases that are too large and too difficult that bog them down for many years, and I'll come back to that in a minute. But small steps that are well publicised are very important. I note that the Saudi Arabian agency has a website where they publish a media release on every decision they've made, even decisions to hold a meeting they publish. So they are some of the methods that have been used that seem to me to be, that certainly have been very successful. One of the problems that small agencies and new agencies has is, as I've said, there is an inertia, to say the least, in the business community. And so education, focusing on education, short-term and long-term, is fundamentally more important, in my experience, than taking on big decided cases that bog you down the courts for a long time. And to use a very simple example, Mexico started with some very major cases when the Commission was first established. It took them 10 years to get out of constitutional court cases before they actually had one case decided. That wasn't a very good message for the community. Certainly was a very negative message for the business community in terms of the need to comply with competition law.
Thank you, Russell. We actually have around 30 minutes. We won't keep you, Russell, standing there, so please feel free to sit and get the mic closer to you.
I will.
فإذا في أي استفسار الأخوة الكرام، احنا حابين نوضح إنه البرنامج اليوم كان سلسلة متحدثين ومن ثم جلسة مفتوحة بحيث إنه نتيح مجال للإخوة للاستفسار والاستفادة من الخبراء اللي معنا اليوم، ولكن بما إنه في وقت أيضا ممكن نترك على الأقل مساحة لسؤالين أو ثلاث. إذا حد عنده رغبة بنقرب له المايك. Please, yeah, there's a hand over there. في مايك. في غير هذا المايك في آخر.
Saying if we don't get enough questions, I'm threatening to show you the rest of the video.
نشكرك على هذه الورقة الجيدة التي استمتعنا بها. السؤال باللغة العربية. حضرتك حينما تحدثت في مسألة المنافسة واضح ان حضرتك اتكلمت على نوع من انواع الرقابة، نقدر نقول البوليسية لسياسات المنافسة بين الشركات يعني. في نوع من انواع التواطؤ بين الشركات. هذا التواطؤ له اساليب لكشفها، لكن ارى ان هذه الاساليب من الممكن في مجتمعاتنا او بمعنى اصح في النظام اللاتيني قد تصطدم بمساله تتعارض مع قانون الاجراءات الجنائيه ومع القانون الجنائي ايضا. في بعض الاحوال ما نقدرش ان احنا نقول والله ان احنا لازم نراقب الشركات ونقول لها انت هتتصرفي على تصرف معين، او ان احنا نقدر نقول لهم انه التواطؤ بتاعكم ده يشكل جريمه جنائيه الا اذا كان منصوص عليه في القانون. وللاسف ان معظم القوانين اللي موجوده فضفاضه، المواد بتاعتها فضفاضه ليست محدده. ما نقدرش ان احنا نقول ان في تجريم بالمعنى الجزائي للاحتكار او للتواطؤ بين الشركات. دي رقم واحد. رقم اثنين، بالنسبه للمنافسه حضرتك اتكلمت على مساله المنافسه اللي موجوده في الدوله داخل الدوله نفسها. لكن انا ارى انه في ايضا احتكار كبير جدا على المستوى الدولي محدش بيتكلم فيه. يعني مثلا لما نيجي نتكلم على احتكار بعض المنظمات زي مثلا منظمه الفيفا اللي هي اتحاد كره القدم، هي تحتكر منتج، ده أليس هذا نوع من انواع الاحتكار؟ تحاول منظمه التجاره العالميه ان تقوم بنوع من انواع التحرير للتجاره، لكننا ايضا نصطدم ببعض السياسات الدوليه التي من شانها ان تمنع المنافسه وايضا تقوم بالاحتكار. ما تنساش حضرتك مثلا الاجراءات التي قامت الولايات المتحده الامريكيه بفرضها على الصين، الاجراءات التجاريه، وهي نوع من انواع نقدر نقول برضو المخالفه واضحه جدا لقوانين ومعاهدات منظمه التجاره العالميه. فانا شايف ان مساله او ارى يعني ان مساله التنظيم التنافسي يجب ان يكون على المستوى الدولي اولا. يجب ان يكون في نوع من انواع النظر الى المنظمات والى الكيانات الاقتصاديه الكبيره التي تحتكر بعض الانشطه، تمام، ولا يستطيع احد ان ينافسها فيه. ده في البدايه. اما في الداخل ففيه نوع من انواع الاساليب الاخرى اللي هي ممكن ان تكون رادعه اكثر من التنصت او التصنت او ملاحقه الشركات وان احنا نضيق عليهم، لان برضه هيكون في شعره قويه او شعره يعني دقيقه شويه ما بين حريه المنافسه وبين مراقبه الشركات والكيانات الاقتصاديه على انها تقوم بنشاط اقتصادي معين. شكرا جزيلا.
ممكن عذرا تعرف بنفسك بس الاخ الكريم.
حاضر. دكتور حموده فتحي، معهد العالي للقضاء في سلطنه عمان، استاذ القانون التجاري في المعهد العالي للقضاء في سلطنه عمان.
Thank you very much. That was a very very interesting comment, and I wouldn't presume. In my speech, I particularly made the point that every country is different. There are some common themes, but every country is different and must choose the path, the road that best suits the economic, social, and political circumstances of the country.
Russell, if you kindly have the mic closer, maybe. Or
I'm sorry, a bit closer. Is that better? Every country is different, and all of these laws, although they have a common theme, must be applied in each country, having regard to the circumstances of that country. And so, on your first point in relation to criminal proceedings, we will come to that later in the day. But the case that I was showing you, the video, was not a criminal case. It was a civil prosecution case in the Netherlands. Now, in the Netherlands, police powers can be used to investigate cartel behaviour, but for most of the world, and I think there are still a minority of countries in the world, Peter, that have criminal cartel laws. My own country, for 25 years, it was a civil law. But the investigation that occurred in that video and the cases to which I referred in my speech were all civil cases investigated by the Competition Authority and brought to court by the Competition Authority. Of course, in my system and in many other systems, it's only the court that can determine whether or not what occurred amounted to a cartel. All that the competition agency can do is bring the matter and present it to the court after a full investigation for the court to decide. And sometimes the court decides that it was a cartel, and sometimes, or monopolisation, and sometimes it decides it wasn't. In relation to the broader issue, a very important broader issue you refer to in relation to the world position, at the moment, the proposition that there might be a world competition agency looking at broader cartels across the world is not something that I think is possible. Indeed, we are facing a situation, as you quite rightly say, sir, where the WTO appellate body will have been not able to sit because in December it will lose its quorum because the Americans are blocking further appointment to the appellate body. So even the WTO, which has been arguably one of the most effective bodies handling trade disputes, not competition disputes, but trade disputes, will not be able to function. So the future is a little bleak in that regard, I think. Your point is a very valid point. What I can say is that competition agencies around the world have cooperated extraordinarily well in dealing with global cartels. And I'll give you an example. One of my lawyers, one of the members of my team, was in Shanghai a few years ago at a meeting of the International Air Transport Association. And the phone started ringing around. There was a meeting of the General Council of all of the major airlines around the world. The phone started to ring. Their mobile phone started to ring. And what was happening that day was a coordinated raid, the Japanese called it a visit, by competition authorities simultaneously on about a dozen different countries to gather evidence for a global cartel in relation to price fixing for air cargo. And that resulted across the world in over $100 million US, 150 million euro, if I remember rightly. 660, thanks Richard, 660 million euro fines being. So when the agencies do get sufficient evidence to prosecute or to take civil proceedings against cartels globally, they are able to do so, but it's exceedingly difficult. So your comment is thank you very much for your comment. It was a very important comment.
Second question is maybe this side this time. Just give a chance to the ladies. Mike.
I think
use
over
my mic till they get my right.
Thank you, Mr. Miller, for your paper and all the examples you have introduced to us around the world. But I have a question about, with all different examples and different focus for countries in initiating the competition policies and laws, how different is it for a big size market country to a small size market country in focus on competition, especially that in the international economy and markets, different economies, we have seen the move toward regulation, then deregulation, then regulation again, and having laws unlike that. How is it affected different for small size market than big size? Thank you.
Thank you very much for your question. That's a really important question. I originally thought, before some work was done by the International Competition Network, that there would be quite a big divide between big countries, powerful economies, very large economies like the EU and the US, Canada, and smaller economies. But interestingly, in responding to that survey to which I referred on abuse of monopolisation policies, the small countries and countries that had new competition agencies seem to have the same sorts of views, concerns and interests as the large countries. Now, when I was favoured with a visit from the chairman of the new Filipino Commission a couple of years ago, it was only established a few years ago, he and his members of his council came for a visit, went for a visit around the globe, I think, but also came to Australia. And the issues that they were concerned about in relation particularly to monopolisation in the Philippines were as significant to their market as they were to my market. And I think one of the reasons I used the example of Mauritius is there is a small country with a small market that has seen tangible benefits from an effective competition law effectively enforced. I hope that helps.
Yeah, last question before we take a break.
Usama Al-Farhan from Sultan Qaboos University. So the question is there any international evidence on the effectiveness of monopoly taxes as a deterrent to monopolistic behaviors and practices, especially when compared to the cost of persecution and the probability of actually having effect on monopolistic behavior? So the comparison between monopoly taxes and persecution as a tool to deter monopolistic behavior.
Well, thank you very much for that question. I'm very pleased at the start that I made the admission that I'm not an economist, that I'm a practicing lawyer. So your question, although very important and a very interesting question, is beyond the field of my experience. My two colleagues who are speaking later in the day, we may reserve your question to see if they have a view on it, but I'm not aware of any empirical work in the field. It's a very interesting question, and I'm sorry I don't have an answer for you.
Thank you, Russell.